Well, good evening, everyone, and welcome back to AJ 101 Criminal Law Online. And tonight we're going to be discussing Chapter 3, the elements of crime and corpus delicti. And that is just kind of cool just because of the sound of it, corpus delicti. Anyway, before we get started, I'd like to remind everybody to take a look at the information at the end of your chapters, including the student review, which has the terminology and the definitions for each particular chapter, the true or false quiz, those questions that will help you study for your weekly quizzes and your chapter exams. Don't forget the short essay questions, which focus a little bit more on some of the larger, more difficult items that we may be talking about that have a lot more to them. And then finally, don't forget about the terminology quiz, which has the terms on one side, the definitions on the other side, and again, make it really easy for you to study. Also, keep in mind that as you go through these chapters, there are several different examples and scenarios on different things that help you understand a little bit more about the subject matter and also help you add some context to what we're discussing. So with that being said, let's kind of jump into corpus delicti. Now, when we talk of this, a lot of people think that we're talking strictly about like a body. So for a homicide case, you need the corpus delicti, the corpus. Everybody kind of associates that together with like homicides, and that's really not the truth. The corpus delicti is known as the total body of the crime. And the key ingredients there are the act or omission to act, meaning the failure to act, and the existence of what we call the criminal agency or the person or the suspect. And you might hear the word perpetrator, which kind of means suspect or pretty much the same thing. Now, the corpus delicti deals with rules of evidence which govern the commission of crimes, proof of act, and criminal agency, as opposed to harm caused by an act of loss, damage, or injury by accident or misfortune. So the corpus delicti, or substance of the crime, is in essence applicable to any crime and relates particularly to the act, element of criminality, that a certain prohibited act has been committed or result accomplished, and that it was committed or accomplished by a criminal human agency. So hopefully that kind of clears up some of the things that are out there. And we're going to talk a little bit about crime elements now, and then we're going to bring it all back around to what we call the proof of corpus delicti, and it'll all tie in. So crime elements, as a practical matter, the Penal Code definition of a crime clearly states those essential elements necessary for the commission of a particular crime. Now, the elements of a crime can be determined from carefully reading the statute. And so when you look at elements here, and you're looking at the slide before you now, crime elements come from the codes. And there's a lot of codes. There's quite a bit of codes that we've talked about before, but we're going to be in the Penal Code right now. So as I kind of said, we'll use burglary as an example. So example, in the crime of burglary, Penal Code 459, reference is made to number 1, anyone who enters; number 2, a certain kind of structure; number 3, with intent to commit grand or petty theft; and number 4, any felony therein. So in this case, the certain essential elements to the commission of this crime are reflected by analysis of the code section. The elements of specific crimes will be explained a little bit later in some of the other chapters. Now, in addition to some of these crime elements, some crimes also contain what we call judicially applied elements. And these aren't always found in the Penal Code or the Vehicle Code or whatever code you're looking at. They're found more in case law and in jury instructions. So again, these are judicially implied elements. And these extra elements, again, Won't be found in the statute, but only in the case law. And typically they will find them, again, published in jury instructions known as CalCrim for California criminal. So here's an example, and we'll use robbery, Penal Code 211, as our example here. So the statutory definition of robbery contains four elements to make up that particular crime. Taking property possessed by another from the person or presence of the victim, against the victim's will, and finally by means of force or fear. Now we'll talk more about robbery later on in chapter 15, but CalCrim 1600, which are the jury instructions, okay, add on an additional element that has to be proven to establish robbery, and that is that the perpetrator or suspect must have intended to permanently deprive the owner of possession or withhold possession for a certain period of time to diminish the value. And although reference to the code section defining an offense will usually be sufficient to identify all the essential elements, this may not always be the case. So that CalCrim definition that I was talking about should also be looked at. So hopefully that kind of makes sense to everybody. Now we're going to kind of bring it all around and talk about proof of corpus delicti. So we know the definition of corpus delicti. We know the elements of crimes, and now we're going to look at, well, how do we prove that corpus delicti thing, that cool word? Well, the prosecution must establish the corpus delicti of a crime. Now, failure to do so is to basically bar further prosecution, meaning that you can't do it. Now, the amount of proof needed need not go beyond what they call prima facie, meaning like face value proof. Okay, you may also have sufficient evidence of the corpus even though you're lacking proof of all the elements of the crime. So hopefully that kind of makes sense to you as well. And the corpus delicti and the elements of the crime are not the same thing, so let me try to clear it up a little bit further here. The amount of proof, again, not need go beyond prima facie, on its face proof, and the prosecution is said to have a prima facie case even when evidence in its favor is sufficiently strong for the defendant to be held to answer for it. Now, because the corpus is simply proof of injury, harm, or loss caused by criminal agency, the term corpus delicti is not synonymous with the elements of the crime. Okay, so here's an example. For example, the corpus delicti of all homicides is the same: death by criminal agency. Does that make sense? But the elements of first-degree murder, second-degree murder, voluntary manslaughter, and involuntary manslaughter are all different. So there is no requirement of independent evidence of every physical act constituting an element of an offense, so long as there is some slight or prima facie case showing of injury, loss, or harm by a criminal agency. So again, the corpus of a crime, that corpus delicti, may be proven solely by circumstantial evidence. However, the identity of the perpetrator cannot prove the corpus. The motive is not part of proving the corpus. And the law does not permit establishing the corpus delicti of a crime based solely on the confession or admission of the accused. Now, you can certainly use that person's statements to further your investigation, but you can't use those statements to establish the corpus delicti of a crime just based on those statements. So, give you a little bit more circumstantial evidence. The corpus delicti of a crime may be proven solely by circumstantial evidence. Thus, as I said before, the essential elements of the crime of murder may be established without producing the body of a victim. Similarly, a genuine, unaltered photograph depicting the defendants involved in, let's say, a sex act was held admissible and sufficient to prove the corpus delicti of the crime of 288 of the Penal Code. So the identity of a perpetrator of a criminal offense is not a necessary and essential part of the corpus delicti, nor is such necessary to establishing proof of corpus delicti. Thus, in order to prove the corpus delicti of burglary, it is necessary to prove that entry of the structure was made and that it was done with specific intent of committing a theft or felony. However, it was not necessary that the identity or the name of the person who entered be known to the police to establish the crime. And again, I'm hoping this is kind of making sense to everybody here. So let's round it up a little bit and kind of move on as we talk about and finish this thing called corpus delicti. So here's an example. Suppose a suspect admits to several burglaries, the location of which he cannot recall, and the crimes were never reported. So let me ask you, can the suspect be charged with those crimes? And I'll give you kind of a second to think about it. So the answer here would be the suspect cannot be charged with the crimes unless the corpus delicti of each crime can be established independently of the suspect's admissions. So hopefully that kind of clears up a little bit of that, and we have a better understanding about corpus delicti. Now, moving on to the Criminal Act. Penal Code Section 20 states that in order to constitute a crime, there must be a unity of act and intent or criminal negligence. Now, you need these to have a crime. And an act is simply defined as an effect produced through consciousness, exertion of will. The act varies with each type of crime, of course, and for that reason, it's kind of difficult to define. In some cases, it may be a physical or muscular movement, while in others, it may be an omission or failure to act. The act may involve passive participation in the crime or activity outside of the state which results in a crime within the state. It could be a series of acts, proximate results, or just mere doing something that will result from some human agency, if that makes any sense. For example, in homicide cases, the act is the killing of a human being. In larceny, it's the taking and carrying away of personal property of another. In arson, it would be the burning of real or personal property. And all of this unity of act and intent or criminal negligence needed to constitute a crime is called concurrence. This is also known as joint operation and intent, and we're going to talk about intent in just a few more minutes. So the act, again, is defined as an effect produced through conscious exertion or will. So here's a couple of examples that we can look at when we talk about omission to act and things like passive participation or acts of possession. And as you go through your textbook, you're going to see a couple of those different things, and we're going to hit on a couple of these to kind of clear them up. So the omission to act, which would be failure to perform a duty imposed by law. An example of that could be failure to pay your taxes or child endangerment. Passive participation could be criminal liability that could result from passively participating in a crime. An example would be maybe providing drug paraphernalia to a user. And that could be passive participation. And then finally, acts of possession. You may be convicted of a crime simply by possessing an illegal item. Now, these offenses generally require knowledge as a state of mind, but an example could be possession of stolen property. Knowingly possess stolen property. So those would be one example of acts of possession. So multiple offenses punishment. Punishment for two offenses arising from the same act is prohibited by the Constitution of the United States and again by the California Constitution, Article 1, Section 13. Also, Penal Code Section 654 states as follows, and you can read along: whenever an act or omission could be punished under more than one statute, it is to be punished under the provision imposing the greatest punishment, but may not be punished more than once. And we've talked about being charged for the same thing twice, or double jeopardy, and things like that. So proximate cause. Let's talk a little bit about what is causation and what is proximate cause. Now remember, we're still talking about this big overriding umbrella of the elements of crimes and corpus delicti, and we've kind of gone through the corpus delicti, and we're moving on now to this thing called proximate cause. Well, Cochran's Law Dictionary, the police edition, defines proximate cause as that which produces an event and without which the event would not have occurred. And I know that sounds kind of funny, but you'll catch on to this in just kind of in a second. So in order for this to happen, there needs to be some causal relationship or proximate cause that has to exist between the defendant's act or the act of another in his behalf and the prohibited result which constitutes the crime or the injury. This causal relationship is said to exist when a defendant's act was the proximate cause of the injury inflicted. So to be proximate, the defendant's act need only be a contributing cause, as in the case of concurrent acts of two persons acting with common design. Now, generally speaking, it may be said that the defendant in a criminal case may not be liable for remote and indirect consequences of his or her acts. He or she, however, is liable for the direct and proximate consequences of their acts. Well, so kind of as we review this, and I know that's a lot of legalese, and that's why the book is really important. So causation, the causal relationship between conduct and result. And that relationship can lead to criminal liability. So that's a kind of an easy way of looking at that legalese I just went over. And this relationship will exist when a person's act is that proximate cause of the injury. A defendant is liable for direct or proximate causes. A defendant is not liable for indirect or remote consequences. So I think that I hope that kind of makes it a little bit easier to understand. So let's look at this interesting thing still under proximate cause, and we're going to talk about attributed liability in homicide. So California courts recognize three theories attributing liability in a homicide case that results from the commission of other crimes. Now, these three theories are the felony murder rule, the vicarious liability doctrine, and the provocative act liability. And we are going to take a look at each one of these so you'll have a pretty good understanding on what it is. So under the felony murder rule, under this rule, if a homicide occurs during the commission or attempt to commit certain serious felonies, rape, robbery, etc., it is first-degree murder regardless of whether the killing was intentional or unintentional. Okay, so just to kind of rehash, so you're there with me, under the felony murder rule, all persons aiding and abetting, okay, the commission of any felony listed in Penal Code 189 for first-degree murder are guilty of first-degree murder when any one of them kills in furtherance of the common design. Okay, that's the more legalese type thing. Now, the felony murder rule does not apply to situations in which the intended felony victim kills a suspect in self-defense or where a suspect is killed by responding police. It applies only if one of these suspects kills in furtherance of the criminal conspiracy. So as we look back up here now, this legal doctrine derived from common law is now found in Penal Code 189, and you can look that up if you want. And again, the killing must be in furtherance of the common design, and there's a case that kind of goes with it, but I think everybody kind of understands it. So let's move on now to the vicarious liability doctrine. So the vicarious liability doctrine holds that where two or more suspects have agreed to kill as part of their plan to carry out their crimes, each of the perpetrators or suspects is guilty of murder when any one of them kills. So that's, let me kind of read back in here. Vicarious liability applies to hold one person liable for the actions of another when engaged in some form of joint or collective activity. Now, in California, where two or more people agree to kill as part of their plan to carry out their crimes and one of them does, they are all guilty of murder. And here's a great example that's listed under here for us. So let's just say that a carload of gang members agree to do a drive-by shooting. All of those suspects would be liable if one of them does in fact shoot and kill. So that's vicarious liability. And now the provocative act theory. So under the proximate cause provocative act theory, surviving accomplices can be convicted of murder when the intended victim or police kill one of the accomplices in response to a provocative act committed by one of the surviving accomplices. And I know that's very, very kind of legalese-ish. However, if the suspect who committed the provocative act, such as starting a gunfight, is killed by a third party and none of the other suspects committed any such provocative acts themselves, they cannot be convicted of murder for their co-conspirators' deaths. So let's kind of read into it a little more simplistic now. The provocative act doctrine applies when someone commits an act that provokes someone into killing someone else. The classic example here is an attempted murder in which the victim is provoked into firing a gun in self-defense, killing a bystander or an accomplice in the attempted murder. So somebody that was actually, the accomplice. The California Supreme Court did narrow this doctrine by making it clear that to be guilty of first-degree murder, all participants must act willfully, deliberately, and with premeditation. So this is the provocative act. So moving on to scope of criminality or scope of criminal liability, except in strict liability cases, all crimes require, an act or omission to act, intent or criminal negligence, and this is stuff we've kind of gone over, concurrence, which is that unity of act and intent, and causation, conduct that leads to an end result. So when we look a little bit more broad now, we're still under the scope of criminal liability, but we're kind of looking a little bit more into, we're starting to move into like intent and some different things like that, which will help us kind of put some of these pieces together. In common law, our understanding of criminal liability derived from a couple of Latin terms. And the first one we're going to talk about is the term actus reus, which means the act. And the act itself can consist of commission, meaning the act of doing, omission, like the act of not doing, or possession, like the act of possessing. The term mens rea means guilty mind. usually referred to as intent, and we'll talk more about intent in just a few minutes. And most modern penal codes have created levels of mens rea, called what they call modes of culpability, but most penal codes will actually list the different types of intent that are there. So let me kind of go into this a little bit more broad when we're talking about criminal intent. So in every crime or public offense, again, there must exist a union or joint operation of act and intent or criminal negligence. Remember Penal Code 20. Criminal intent is the second of the two elements. The first is the act necessary for the commission of every offense. Now, intent is a mental element of the perpetrator or the suspect, often referred to, if you kind of just look at the slide we had before, mens rea, or the guilty mind of the individual who fosters the criminal intent. Now, not all crimes require the same intent. Some crimes, by their very nature, require a particular designated state of mind, like burglary, larceny, theft, assault. For example, to commit burglary, one must have entered a structure with specific intent to steal or commit a felony. A second example is seen in the crime of theft. Here, there must generally exist a specific intent on the part of the suspect to permanently deprive the owner of their property. So you'll see that there are different types of intent, and some of them will have what they call specific intent, and we'll get to that in a minute, and then some will have what they call general intent. But criminal intent is defined as a design, resolve, or determination of the mind. Penal Code 21 subsection A states that intent is manifested by the circumstances connected with the offense. Criminal law states under Penal Code 26 that all persons are capable of committing crimes except those listed in that particular penal code, Penal Code 26. And an unlawful act is presumed to have been done with the intent to violate the law. So what are those types of intent that we're going to be talking about? And how do we use that to kind of further our case as we're starting to work this? Well, there are three types of intent, or three main types of intent. The first is general intent, the next one is specific intent, and the last one is transferred intent, or what is also known as constructive intent. And we'll take each one of these individually so we can get a good handle on them. So most crimes are what we call general intent crimes. And the elements are the mere doing of an act in violation of the law without legal justification or excuse. Now, general intent may exist even when one thinks their acts are right or lawful. And again, the law presumes that persons intend the consequences of their acts. So that's kind of more the general intent. A general criminal intent is sufficient in all cases in which a specific or other particular intent or mental element is not required by law defining the crime. So most crimes, again, are kind of general intent in nature. Now, specific intent, when a crime consists not merely in doing the act, but doing it with specific intent, the existence of that intent is an essential element of the crime. And the existence of criminal intent is not presumed from the commission of the act, but the specific intent must be proven as an independent factor. So when a crime consists of not merely doing the act, but doing it with a specific intent, that intent is an essential element or piece of the crime. And again, that statute may require a designated state of mind necessary to commit the crime. And generally, when you look in a lot of the statutes or the codes, you're going to see some language, as the example shows here, every person with the intent to or for the purpose of blah, blah, blah. So it will actually spell out what the intent is. And, again, depending upon how they word that, but they will put that information in there, and it'll make it easier for you to figure out what is general versus what is specific. Now, the last type that we're going to discuss here is called transferred intent, also known as constructive intent. And transferred intent, as I said, also referred to as constructive intent, involves crediting liability to the suspect for the unintended consequences of his or her acts. Thus, where a person is engaged in an unlawful act, commits another unlawful act unintended by him, the intent to commit the first act is carried over to the act actually committed, if that makes any sense, and that is called transferred or constructive intent. So let's kind of go through it again. Defined as crediting liability to the suspect for the unintended consequences of their acts. The intent is transferred from the party who was the intended victim to the unintended party that is the subject of the loss or injury. Now, here's a really good example. John intends to shoot Steve. He misses and instead shoots a bystander named Cindy. We transfer John's intent towards Steve to the injury received by Cindy in this case, and that makes it basically an item of transferred intent. So hopefully that kind of clears that picture up a little bit. So now that we know the three different types of intent, how do we prove it? How is intent proved? Well, criminal intent, general, specific, transferred, the ones that we've been talking about, may be proven by circumstantial evidence and may be inferred from the manner in which the unlawful act was committed. Intent, all three of those types that we've been talking about, may also be proven by direct evidence, such as words spoken by the defendant or by the circumstances surrounding the crime. The accused may have told someone of his or her intention before committing the crime. Also, the suspect may have made a statement like, "This is a stick-up," or "This is a robbery," during the commission of the crime. Words spoken by the accused during an assault may very well reveal that person's intent if you're talking about like a rape case or a sexual assault case. So, kind of in review, criminal intent may be proven by direct evidence, an eyewitness. Criminal intent may also be proven by circumstantial or indirect evidence and may be inferred by the unlawful act committed. And the conduct of the defendant before, during, and after the offense is admissible to prove intent. So you have three different concepts here on basically how intent is proven. Well, what about in negligence cases? Because we've all heard that thing, and we know what crimes are, but let's talk about intent for just a moment in negligence cases. Well, to be guilty of a crime, a person must act with, remember, mens rea or criminal intent, right? Normally, this means intentionally or deliberately pursuing a criminal result, but criminal negligence may substitute for criminal intent under certain circumstances. And this negligence is usually stated as a wanton or conscious disregard for the safety of others, or what they call willful indifference. And there are 5 factors basically that are looked at to consider, in order to find intent from criminal negligence. So we're going to kind of take a really quick look at these five. So the defendant must have a legal duty or contractual relationship, if you will, towards a person, group, or society in general. Defendant must know or reasonably should have known that he has a legal duty, that there is a present existing danger. There must be an apparent ability upon the part of the defendant to perform the legally imposed duty. It must be shown that the defendant failed to perform the duty which is legally performed. And then finally, it must appear that the defendant's negligent act or failure to act, omission, was in fact the cause of the injury. So here's an example that we can kind of look at. If an operator of a motor vehicle who drove in excess of 50 miles per hour in a residential area and killed a pedestrian whom he did not see was guilty of gross negligence and manslaughter. In this case, and it's People versus Flores, Flores, the person in the case, had a legal duty to drive within the speed limit. A lack of due caution, okay, referred to in 192 of the Penal Code, which is manslaughter, places a criminal responsibility on a person who acts without due caution and circumspection and is equivalent basically to criminal negligence. So there's an example of criminal negligence. So then finally, as we start to kind of finish up here, we're getting close. We'll talk about malice. Malice means a wrongful act done intentionally without justification. It's found in Penal Code 7, Penal Code 188, Penal Code 450 to define different types of crimes. Now, there are two types of malice when we talk about these. There is expressed malice, and you can look at Penal Code 188, which is the deliberate intention to kill another. And then there is implied malice, which you can find in Penal Code 188, where the killing shows what we call an abandoned or malignant heart, cold-hearted, disregard for other safety. So these are the two types of malice that you will definitely see as you start to look more into dealing with criminal law and things like that. Now, there's a couple of other types of malice that are listed in your textbook that I thought I might take just a minute to talk about. Malice in vehicular murder, malice in criminal negligence. Those are both a couple of things that you may want to look at. So in the vehicular murder, if a person drives with such wantonness and conscious disregard for life as to a support of a finding of implied malice, or if he drives under facts which show express malice, that person can in fact be charged with murder. So you can see how malice plays a big part in that. So up next, we're going to talk a little bit about motive and what that is. Motive is never indispensable to a crime or criminal prosecution, nor is it an essential element of a crime. Motive is basically the desire or the inducement, why, okay, which incites or stimulates a person to do an act, as contrasted with intent, which is the purpose or the resolve. So while motive is not a necessary element of a crime, it certainly may help to prove the intent necessary for the consummation of a crime. So we definitely want to kind of understand that. So motive is the desire or the inducement which incites or stimulates a person to do an act, as contrasted with intent, where we just talked about. So an example, one may administer a lethal drug to a terminal cancer patient to hasten death and to relieve pain and suffering. Now, while the motive in the eyes of some persons may be good, the act itself is no less criminal homicide. Similarly, a parent who neglects to provide medical aid for a dependent child in violation of a criminal statute cannot thereafter excuse him or herself on the grounds that he or she was actuated in such refusal by religious motives, meaning that you can't use religion to basically not provide for your kids, if that kind of makes any sense. And I know that, again, some of this is a little bit difficult to understand, but that's why we're really taking the time to go through with it. The law does not seek to punish a bad motive, but only the criminal acts that result from such motive. Thus, unless one's illicit motive actually results in a criminal act, there is in fact no crime. So as we finish up the chapter, we'll talk a little bit about intoxication affecting intent. And there's a couple of areas. There's voluntary intoxication, which is under Penal Code 29 Penal Code 29.4. And then there's a couple other things that we'll hit on, and then we'll be done for the end of the chapter. So when we talk about intoxication as affecting intent, evidence of voluntary intoxication shall not be admitted to negate the capacity to form any mental states for the crimes charged with which the accused committed the act, including but not limited to purpose, intent, knowledge, premeditation, deliberation, or even malice aforethought. Now, even if you look at motive and corpus delicti, as previously stated, motive is not part of that corpus delicti of any crime, okay, and need not be proved. Evidence of motive, however, is quite often valuable in removing doubt in the jury's collective minds. Motives may either be shown by direct testimony, or it may be inferred from the facts surrounding the act. Motive in such cases becomes a circumstance to be considered by the court or jury. By the same token, absence of motive may be a circumstance in favor of the accused, the suspect, and can even be given such weight as the jury deems proper. So, when you can see how motive is important in a lot of different fashions. And then finally, finishing up diminished capacity, the defense of diminished capacity was abolished by the passage of Proposition 8. We heard about that a little bit earlier. Defendants utilizing this defense in the past maintained that due to intoxication, trauma, mental illness, or the effect of too much blood sugar on the brain, they did not have the capacity to form the necessary criminal intent to commit the crime in which they were accused. And Penal Code Section 25A abolished the defense of diminished capacity in any criminal action and any juvenile court proceedings as it relates to capacity to form particular purpose, intent, motive, malice aforethought, knowledge, or other mental state required for the commission of a crime. So evidence of diminished capacity or of mental disorder may still, however, be considered by the court, but only at the time of sentencing or other disposition or commitment after the issue of guilt or innocence has kind of come forward. So again, one of those good chapters for you to kind of go back through and look at these different areas that I've been referencing, read some of the areas that may not be quite as clear as you were hoping that they would be, and also, again, at the end of the chapter, look at the terminology area, look at the true-false quiz, look at some of the discussion essay questions, and also look at that terminology quiz where they have the terms and the definitions kind of set apart, and you get to match them up, because that really will, I think, help you as you move through all of these chapters. So that's going to be it for Chapter 3, and until next time.